the backlog. We have to acknowledge that this year we had a lockdown. With the lockdown, there were a lot of activities that could not take place. And the parole board sessions during the lockdown, they didn't take place. And the Department of Correctional Services also has to consider a strategy for reducing the population as a part of containment of the spread of the virus. With that, a lot of effort also was utilized at looking at how we could reduce the population while also we limit the people that are coming in. So the parole board processes, they were sort of affected. But the consideration of the increase in the population, it made the department to review its risk-adjusted strategy. So as from with the revised risk-adjusted strategy, the parole board has been allowed to function in all the levels. But initially, the parole board was not working when we had a complete lockdown. With regard to the psychologists and the social workers, chairperson and the parole board, I would like to say, in as much as the reports of the psychologists and the social workers are critical for the consideration of cases, the department has got a serious shortage of psychologists. And the shortage of psychologists is known in the whole country because most departments that are using the service of psychologists, they have got posts that are vacant, that are not filled, even if they are financed, because psychologists normally do not stay in the field of psychology, a lot of them. So that's the problem that the Department of Correctional Services is experiencing. With regard to who is responsible for the component, okay, these psychologists, are they full-time employed or the contract employees? No, the psychologists and the social workers are included in the staff establishment of the Department of Correctional Services. So they are full-time, they are social workers and psychologists. And then who is responsible for the psychologists in the department? They fall under the branch called it's Incarceration and Corrections. Then there is the post of the chief director responsible for the psychologist and the social worker is vacant at this stage. So there's a rotation on the people that are acting in that post. Thank you, Chair.
So I've noted, Honorable Yago, before you come in, Honorable Yago. So are you saying all this backlog, Deputy Commissioner, just happens because of the lockdown? So all this backlog was not there before the lockdown. It just happened before the lockdown. Is that what you're saying?
Chair, I'm not equating the backlog to the lockdown. I'm saying the lockdown also has contributed the lockdown has contributed in the backlog, since the operations of the parole board, which are very critical in processing these cases, they were not taking place. So I'm not really equating the lockdown only to this backlog. It contributed to the backlog that was already existing, Chair.
Honorable Yako.
Thank you very much, Chair. I think you covered a part of what I wanted to ask, is that the lockdown is solely the reason we are sitting with a backlog, because I know currently of many social workers who are sitting without employment, and if there's spaces for them to have employment in certain spaces, then why aren't they having the opportunity to apply? Secondly, I would like to ask the department, perhaps with the approval of the committee, to come back to us with a strategy as soon as possible, I would say within a week's time, of how they intend to mitigate the many impediments that they've put in front of us as to why it cannot be performed, that this backlog is then attended to as soon as possible. Remember that we've had to, during the time of COVID, we've had to let go of many prisoners who were supposed to be in prison for, I mean, something as basic as 2 years, because there's too many prisoners in the prison space. So why are you not prioritizing those that should not be then in the system so that they could move out, and then we remove with the number that we have? It seems to me that there's no plan to work on this, but just to report to us that, look, here are the stats. What do we do with the stats? Nothing. If you don't have a plan to say, this is our plan, and COVID out of it, because whatever plan you have right now has got nothing to do with COVID, in my opinion. COVID does not impede on you performing interviews. COVID has no impediment. If in fact COVID should accelerate your need to then move with this with these regimes, that these parole regimes that you proposed. So I would appeal that we have a strategic plan from you, Ms. Foye, to say that this is what our plan is, and this is the deadline of the plan, so that we can hold you to it. As it is, I'm not impressed with your reply in terms of why there are impediments to this happening at the moment. Thank you.
Thank you very much. I think the chair of the subcommittee is also listening. Honorable Janji.
No, yes, Chair. In fact, Chair, what I was going to say is that starting with Honorable Yako and an entire department, that we have a date with them. They must diarize a date that we have agreed yesterday, Chair. That date is about them coming to us, which is not in a week's time or 2 weeks' time, unfortunately, Honorable Yako. It's for the department to come to us and present to us what we call the intervention on the key failures of the department. And we're going to be telling them where those failures are, and they include these issues of backlog. So we have a date set for that, so that they come back and present fully, but they are not going to be all over, because we've been with them. We know where their failures are. They must come and explain how they are turning us failures. It is your old thing of saying a turnaround strategy, but we have broken it down and moved away from a turnaround strategy to say, we were here with you in the annual report from 2019 and the subsequent meetings. These are the things we have identified that you are failing on as a department. And that date of the 5th of March, they are coming to present how they are turning around each of those key elements. It's not going to be one. So I'm asking that people, I'm dating people here. Come on the 5th of March. We have a very good session. I'm looking forward to it. And they rather start preparing today for that date. Thank you, Chair.
Thank you very much, Honorable Janji. We are looking forward to the date. I see, before Honorable Mfokeng, welcome. I see CDS remand detention. Do you want to say something?
Good morning, Chairperson, honorable members of the Portfolio Committee.
Your voice is too low. We can't hear you.
Good morning, honorable Chairperson of the Portfolio Committee, honorable members of the committee. My name is Cynthia Ramuripo, Chief Deputy Commissioner, Remand Detention, leading the team. My apology for failure in terms of the connectivity, but I've managed to connect in time. I would like to request through the honorable chairperson to make additional submission on the respond to the questions regarding the factors that has also impeded on the backlog is also has contributed, especially transfers and resignation. We have a staff establishment strategy intervention that it has been in place.
Sorry, citizen. I think you might have listened to Honorable Janji. There is a plan by the subcommittee that would allow you to make all those presentations to the subcommittee, and they are thoroughly interrogated there. I would ask that you would be informed as to the dates that you are required to come and present those detailed plans and those additional information to the subcommittee of correctional services. Is that agreeable, members?
Yes, sir. We will do
Yes,
so.
Chair.
Thank you very much. Sorry for that CDC remand detentions. I want you to have enough time and then so that it can be properly interrogated by the relevant subcommittee that has got the relevant skills and knowledge and background to what is happening at the Department of Correctional Services, because what we want to really achieve is a turnaround of the department. It's not an issue of question and answers. That issue of question and answers is just
Thank you, Chair.
a vehicle to achieve a turnaround.
Yeah.
Our ultimate aim is to see a turnaround. So we are not really, those question and answers are important to the extent that we see a real impact in the turnaround of the department. So thank you very much, honorable members. Can we move to deliberations now on the bill? The bill has been presented. We have received questions that are directly related to the bill before us, and we have received those answers from the department. We have received presentations from Helen Susman Foundation, from Mr. Buthelezi and others that have been responded to. So there is a bill before us. Can we now go to the bill? What is the feeling of the members? Is the bill before us addressing the decision of the Constitutional Court? Honorable Mfokeng, sorry, I had forgotten you, Honorable. Apologies, my apologies. Please, I had forgotten that you had raised your hand. My apologies. Honorable
No,
Mfokeng.
it's okay, Chair.
Honorable Hall, you're
Thanks,
noted.
Chair. I think you got an apology why I was coming late today.
Yes, we did, please.
Chair, I think I'm covered by Honorable Janji and what actually you summarized on the previous CTC. I'm covered on that. On the one of the bill, I wanted to say that with the submissions that were there yesterday, the one of Helen Susman and of Buthelezi, I'll say that Helen Susman came out very clear, and we agree that it's in order now, and it really is something that goes with our constitution. If there's any other person who's got another view, I think that they have complied now. Thank you.
Thank you very much, Honorable Horn.
Thank you, Chair. Yes, I think that although one can say in principle the stance of the Helen Susman Foundation from a rights-based approach would make sense, I think we must just, from a practical perspective, also deal with this matter. As a matter of fact, me and the Honourable Self just this morning earlier had a quick discussion on it, and he actually, I think, to my mind, gave a very good example as to why, in certain respects, Helen Suzman proposal cannot always be a practical solution, in the sense that if somebody gets a life sentence after committing a murder in society, then in prison at a later date also commits a murder and receive a subsequent additional life sentence, then on a pure application of the Helen Suzman proposal, the first murder will always be the operational and effective date in terms of which parole should be dealt with. So with the greatest of respect, the practical effect could be that we as a country or as a legislature or the department, by consequence, is forced to turn a blind eye to subsequent criminal actions of a same nature. So I think we should rather look at it more carefully. And then in addition, and maybe it is my fault but I still do not really understand how both the Van Vuren and the Van Wyk protocols is properly dealt with by way of this legislation. So if we can just be given a practical example how both of those regimes could be brought home in terms of the amendment, I would probably understand it a bit better. I, in any event, understood the feedback in that regard yesterday to be just a confirmation from the department that they're confident that the implications of both those judgments are covered under the amendment or the proposed amendment, but that they will come back to us formally today in that regard, and possibly also in respect of other matters raised. Thank you, Chair.
Thank you very much, Honorable Horn. Honorable Liako.
Thank you very much, Chair. I think the committee, I would like them to be quite patient with me in that I've just come into justice. However, so some wordings and things I would not be of understanding of them, but I'm learning. And my issue, just like with the previous speaker, was saying the practicality of advancing it, whatever bills that it is that we're wanting to pass. And just like, for example, the gender-based violence bills, yes, you may pass the gender-based violence bills, but how practical is it to carry them out? How practical is it to keep those accountable? And what is our staff complement? And I still think that the department is lacking in terms of a proper plan that says, okay, things are changing and times are changing. Here we've set and decided on what plan we decide to undertake. So I look forward to that meeting on the 5th of March. If I could be invited to just be an onlooker and hear exactly what plan do they have that would then say to me personally as a South African citizen that everything is okay. Our lawmakers are making great decisions. They have everything covered. Because as you speak, we're just talking about, semantics and nuances and words, but actually, in reality, have we actually thought about when we want to roll out these bills, and once they rolled out and they pass through all the various structures, is it going to work? Is it going to mean anything? And the whole reason that we're in Parliament is to make it mean something and to make it realizable. Thank you very much, Chair.
Thank you very much, Honorable Liako. Honorable Swart.
Thank you, Chair. Very briefly from my side, I appreciate the work that the department has done with the draft legislation to, as far as possible, bring it in line with the Constitutional Court judgment. We appreciate the comments that have been made about the lack of capacity. And of course, we've always got to bear in mind the general views around parole and the concerns that we heard when we were dealing with other issues. We even read in, I think, the media recently, the last few days, of an allegation that parolees were, again, committing offences. So that is a separate issue to be discussed at a separate date, the capacity as well. But I don't foresee any major problems from our side in supporting this. I appreciate what the other speakers have said, particularly about the unforeseen consequences had one followed some of the suggestions. Whilst the Helen Suzman Foundation made very good suggestions, there could well be unforeseen circumstances been highlighted. Thank you, Chair. That's briefly from our side.
Thank you very much, Honorable Swart. I see Honorable Mfuke wants to come back. Honorable Mfuke.
Thank you, Chair. Chair, I think maybe we should start as Honorable Yaku was saying that maybe she's learning. She cannot say that she must be invited to the subcommittee. I think they should be represented and they've never attended from their side. And I think she's welcome. Chair, I think when we are accepting the bill and the department has worked hard, they must actually tell us, as they promised yesterday, that they will look at the rules and regulations. When are they going to start on that? And if there can be a time frames on that, then the subcommittee chairperson, Janji, must be able to get that guidance when we meet on the 5th. Where are we going? Because Honorable Swart is right to say that we've been complaining about the parole and the parole system. And we need to know whether they are still going to go on with the review of the parole system, which is very important because most of the challenges that are out there is also about the parole. And we need to go into that to look at what is it that we are having on the table. And we should not forget that the challenges that are there is because we have many parole boards in each and every prison, and that cannot be right. There should be a better mechanism so that there's uniformity and know what is happening. All our problems that are there is because of some of these challenges. Honorable Yaku is right to say that we can have bills, we can have everything, but the implementation becomes a problem if we don't see things coming in the right direction. Thank you, Chair, and we will support the bill.
Thank you very much. So, Honorable Yaku, I think you can make contact with the chair of the subcommittee, because I think there has been quite a number of changes in the representation within your party. All parties are represented in the subcommittee. So between yourself and Honorable Ndlozi, you would decide as to who attends the subcommittee. But even those members that are not members of the subcommittee, they are always free to attend the subcommittee meeting.
I think, Chair, can I just make a decision or an application to you as the chair of this committee that I just be invited as a looker on or as a just a guest. I cannot take away from the decisions that you've made. Remember, this is not my main committee, so but I'm quite interested in how you plan to do things moving forward, because I have quite a few concerns. So if I would be invited, that would be really nice. I would appreciate it. Thank you very much.
I think the date is the date with you is it's on. So whenever I think we will deal with the program which has been circulated. So the dates would be, all the dates of the subcommittee for this term are going to be made known to you, so that for whichever agenda item would want to attend, you are free to attend. We are always happy to have you in the committee. Thank you very much. Honorable Sir.
Yes, thank you very much, Chairperson. I'd like to come back to the point that the Honourable Horn made, and that concerns the proper interpretation of the Van Vuuren judgment in particular. Now, Mr. Van Vuuren, as far as I can read from the Constitutional Court judgment, was serving a life sentence for an offence committed before 2004. And he argued that he should be eligible for parole in terms of what he called the policy and guidelines that were applied by the former parole boards as of 13 November 1992. Now, if I look at the bill, and look at clause 3 of that bill, then it says, as far as I can read, that a person that is entitled to, that was sentenced before 2004 effectively, is subject to the policies and guidelines applied by the former parole boards prior to the commencement of those chapters. But it goes on in B of that clause to say that in the case of a life sentence, that implies 20 years. Now, that wasn't my understanding of what was the implication of the Van Vuren judgment. And I reiterate the point that the Honourable Horn made, that really, I think the department needs to give us the assurance that the formulation that is before us is appropriate to the exact provisions of the judgment in Van Vuren. Thank you, Chair.
Thank you very much, Honourable Self. Can the department respond to both Honourable Self and Honourable Horn's concerns? I would like to make a further suggestion to the committee that, notwithstanding the fact that we know that regulations is a delegated legislation delegated by the legislature to the executive, and maybe the law, the current act, does not make provision for Parliament to approve the regulations, because some acts do make that particular provision. But because of the importance of these regulations and the fact that the act itself is too brief, and a lot of meat will be going into the regulations, and the regulations is part of the delegated legislation to the executive, that before the regulations are approved, that the committee the subcommittee and the committee ultimately must have sight of what is in the regulations. We think that they deal with very important issues. We would like to see what is going to be the final product that comes out of the regulations, and maybe some of the concerns we have might be clarified, but that does not take away the questions that have been asked by, or the concerns raised, or the assurances sought by Honourable Horn and Honourable Self. Over to the department.
Thank you, Chair. I will ask Jack to respond in these two questions, on these two questions, Chair. Thank you.
Thank you very much.
Where's Jacques?
Good morning, Honourable Chairperson. It's Jacques, as in the French lover. It's a French name, yes. So it's Jacques. But pleased to meet you, well. Good morning this morning, Mr. Chair, and honourable members of the committee. I'm also engaged in a court matter today, so I'm juggling with all of this at the moment, but no problem. Sorry, the connection was just terrible the last couple of seconds, especially when Mr. Chair was talking with regards to, or commenting on some of the issues. So I might have missed some of the issues that you have referred to. So I apologize if I talk about things that are not necessary. Can I proceed, Mr. Chair?
Yes, no, you can proceed, sir.
Thank you very much, Chair. All right, I'm going to just want to make a couple of comments first. With regards to issues that were raised yesterday, discussed today, as well as the further questions raised this morning or just now. there was a concern about the various parole regimes. Now, one must understand that the parole regime, although it's, I wouldn't say completely created by court judgments, a parole regime is contained in the Act. The judgments only indicates or requires how the Act is to be interpreted and how the Act must be applied. And specifically with regards to Partla judgment, as I've said yesterday, the gist of the whole judgment, if one can summarize it in one sentence, it is just that the date of commissioning of the crime or offense is used to determine and establish which parole regime must be used. It did not change the parole regime. The parole regime is still the same as it is in the old Act and as it is in the new Act. That's what Partla essentially did. In terms of Van Wyk judgment, Van Wyk judgment also did not change a parole regime per se. It basically just said, in terms of the old Act, Act 8 of 1959 of Correctional Services, it said that an offender qualifies for credits, especially lifers. And in that case, the gist of it was that all lifers were supposed to then receive full credits, as well as the reduction of remissions and special remissions. I've alluded to this yesterday, but for the sake of convenience, with regards to Van Wyk, it did not also change the parole regime. Because if one is thinking, let's look at the example of lifers. The old Act, 8 of 59, says basically a lifer qualifies to be considered for placement on parole after serving at least 20 years. The new Act, or the Act 111 of 1998, the current Act, says 25 years. So that's the difference. So those are the parole regimes in principle. In other words, the parole regime that basically provides what is the minimum detention period which must be served before somebody qualifies to be, an offender qualifies to be considered for parole for the first time. Then in terms of the Van Vuuren judgment, the Van Vuuren judgment solidified the principle in law that one has to look at, well, at the time, one has to look at the applicable law at the date, well, in that case, it was still the date of sentence. That was because it was long before Partla. But it said that the policies and procedures that applies, as well as the law that applies, and that is a legal principle, it's been in our law for a long, long time. The law that is applicable, including the policies and procedures of the department, at the time, well, at that time of sentencing, must be applied. And in that instance, it was more so about parole being only 3 years, and then you are finished with your parole lifer, instead of being on parole for life. So that's one of the issues there. But it didn't change the parole regime in principle. Because if one has regard, in principle, or basically we have currently, for those serving sentences, we have 3 parole regimes. If I can just call it, it's actually 2 parole regimes, but a third one is the Van Vuuren cases. In Van Vuuren, those sentenced before 93, if you read that together with Partla judgment, then it becomes not those who are sentenced or the date of sentence, but the date of commissioning of the crime. So then it changes and says, for those who have commissioned their crimes before 1993, one has to have regard to the law, policies and procedures that were in place at the time when the crime was committed. And at the time when those offenders commissioned those crimes before 93, the law and the policy and procedures stated that you have a lifer must be on parole for a period of maximum 3 years, and then they are done with their sentence. Now, after that, it was obviously amended and it changed that a lifer will be on parole for life. So that's in the gist of it. Partla did not change that principle or that parole regime. It only said that one has to not have regard now anymore to the date of sentence, but you must have regard to the date of commissioning of the crime. And this is exactly as what we submit, Mr. Chair, that the department is submitting to say that it's 100% covered for in this act. Because, this bill. Because this bill obviously is flowing from the Constitutional Court judgment in Partla. And as I've said, the gist of the Partla judgment is that one has to now have regard to the date of commissioning of the crime and not the date of sentencing anymore to establish which parole regime is applicable. That's it. And this is what this bill is doing. If one then relates that to Van Wyk cases. Now, as I said, Van Wyk is about the deduction of credits, etc., etc. But all of those Van Wyk cases fall under the old Act. And the old Act says for lifers, 20 years. And what the Van Wyk judgment then, the implementation thereof or the effect thereof was that it's no more 20 years, which the lifers need to serve, but they must serve 12 years and 10 months. When you minus all credits and you minus all remissions, especially those of 2005 and 2012. So that is in a nutshell what Van Wyk judgment is. The implication of Parla is simply that to determine whether an offender is a so-called Van Wyk category case, one has to not have regard to the date of sentencing anymore, but you must have regard to the date of commissioning of the crime. So to establish whether somebody is a Van Wyk case, one has to simply look at the date of commissioning of the crime. If it was before 1 October 2004, it will then be covered, especially lifers will be covered under the Van Wyk judgment. In other words, they will benefit from that judgment. Coming back, then if one have regard to the concern or the question that was raised, though, can we not just have one parole regime? It would be fantastic, and we agree as a department. It would be it will stop a lot of chaos and create more certainty. However, that is not possible. As we all know, the rule of law says, and the concept of the principle of legality is very clear. One has to, and it was said in the Parla judgment, by the way, one has to have regard to the least punitive measures if the law has changed from the date of commissioning of the crime until the date of sentence, and we add until now. So you must look at the least punitive measures for the offender. Then a further principle or maxim in our law says that in this instance, especially in these instances, one has to have then regard to the law that was applicable at the date an offense was committed. Now, we cannot change what the Act said in 1980, for example. We cannot change what the Act physically on that day, on the 1st of January 1993 said. The Act at the time is what it said at the time. We cannot change it retrospectively. So what basically happens is, if one then applies those principles in law, and let's say, for example, somebody committed their crime or commissioned their crime on the 1st of January 1993, then one has to have regard to the law that was applicable on that day, as well as the policies and procedures. And if it's a lifer, it would simply mean the person will be qualify, the offender will qualify after serving 20 years. Well, at the time, if that was the law at the time, I know there was a couple of other changes of 15 years and so on, but we won't go into that. But that is basically in a nutshell what that situation is. So I hope that one is a bit more clearer. I just want to quickly go to, yes, just a further comment on the Helen Suzman comments. We are of the firm view. An act is supposed to solidify and provide legal certainty with regards to principles in law. How those principles are to be applied and implemented follows into procedures. And we are of the view, and we submit that should be, as DC Mlomo and Glover has indicated, that it should be rather contained in regulations. Because if one has to have regards to only the multiplication of offense for which one is convicted in one sentence, because that's actually what it's about, or continuous offenses, or an offense that is continuous in nature, like theft, for example, as to determine which date now must be used. We concur, as we've said, that it's the earliest date. But that's not the only procedural thing that needs to happen. In other words, it's not a principle. It is the principle is the least punitive measure. That is the principle. And that is contained in the bill, because the bill says we are no more looking at the date of sentencing, we are looking at the date of commissioning of the crime. Now the question arises, what is the date of commissioning of the crime. We submit with respect and humbly so that is procedural in nature. It's operational in nature. Yes, it must provide legal certainty, and delegated law or delegated authority contained in regulations is also in any case secondary law, and it also forms part of the law in any event. We are of the firm view that it need not be in the act itself, but in the regulations, which will still be scrutinized and still go through public scrutiny and all of that. So there's still transparency and accountability and all of that. And also, as we've said, there's a further question as to how far are we, or when have we started? Have we started with regards to the issue of with the review of the act and regulations? Yes, we have. In fact, we've already started last year, or the end of actually of 2019, by obtaining inputs from relevant role players internally, by having certain discussions and all of that. We are busy with the discussion document as we speak. We have just been, I don't want to actually go there, so I'm not going to use lockdown and all of that. So, but the point is, we were just a bit delayed with some of the issues, but we are feverishly busy, even from home, with regards to the issues of legislative review. As I've explained yesterday, one of the priorities for the department is parole legislation and regulations and all of that. And what's going to happen is those policies and procedures that are contained currently in our directives, internal directives and directions of the department, most of that will be contained in the regulations. We are still busy and grappling with this. There's already a draft, by the way, there's already a draft parole bill that we have done. It has not been submitted anywhere. It's still being discussed and we're still busy with that. But that has already been drafted some time ago. Now, because we are still busy with the various ideas as to whether parole should form a separate legislation, in other words, outside the Act of Correctional Services or within Correctional Services Act and remain there. The department has not made a final decision on that, but the inclination is that it should remain as part of the act and not a separate act itself, but that it should just be provided more legal certainty in the regulations. The principles then contain in the act, and the regulations will then. But then was time frames. We are busy as we speak with that. And the idea is, in terms of our plans, we do have plans and we have action plans and all of that stuff. The plan is that by next year, we want to table the regulations, if it's possible, flowing from the Act, because we are busy reviewing the Act and the regulations, especially with regards to parole. The discussion document, it's envisaged that we finish that and that it's circulated by the end of March this year. The discussion document on certain critical areas within the Act and the regulations, which we are busy reviewing. So that is the plan of action, and there's a dedicated team to that. I can just mention, sir, Mr. Chairperson, which is quite important. The Department of currently do not have a legislative drafting component at all. Department or directorate in legal services and a contract management one. So that is also a matter of concern. So you have people that are dealing with these things on an ad hoc basis. Not that it should be a problem or concern for the portfolio committee, but I just deem it necessary to mention that. But we are busy with that and have that component created. So currently it's a task team that is dealing with it. Be that as it may, we are attending to all of these things. We are making sure that we are sorting out the regulations as soon as possible, but we are still submitting that there are many other issues that would fall in the same category, on the same box as what the Helen Suzman Foundation has raised, and we appreciate those. And it's part of our discussion document already, even before these hearings, that those issues. But there are other issues as well, and we cannot put all of those procedural issues into the Act, because we want to make sure, that's why we are revamping the Act, and make sure that principles are catered for in the Act and policies and procedures are catered for in the regulations. Mr. Chair, I've said a lot now, but I hope I've covered in a nutshell, basically the whole kitchen sink. If there's anything more I missed, please indulge me, or please let me know if there's something I've got. Thank you so much for the opportunity, Mr. Chair. Thank you.
Thank you very much, Mr. Jack. I think the part that you did not hear from me when I was still speaking is that we would like to have sight of the regulations before they are operational. Although we know that that is a delegated legislation or delegated power to the executive, but as Parliament, because of the significance of these regulations, we would want to see them before they are made operational, and so that we can have an input, because the meat of the law is in those regulations. So we would want to have an input before they are operational. That is what I wanted to I think when I was speaking, I think that is what you did not hear, but you were able to assure us that those regulations, we would make sure that most of the issues that are concerned to us are in those regulations. But one issue that you might need to consider as a department and also the subcommittee, something that is not, it might not be directly linked to the current bill. It's how do you calculate these credits? There has to be a transparent system that everybody understands. Because sometimes we see people serving 2 months, they are released, we see some, so we have to have, the nation has to have a transparent system how these decisions are made. And Parliament, I think, has to be taken through which formulas are used, how this, a person who has been convicted for a 10-year sentence or a 12-year sentence, how does that person get credits and serve 5 years? So we need the whole process to be thoroughly explained so that the nation can know. The principle of transparency is very important. I think it's one of the issues that maybe the subcommittee might consider thinking about it and putting it in their program of action. Now, Honorable Horn and Honorable Self, having had the response, I've noted you, Honorable Mfuke, having had the response from Mr. Jack, what is your response?
Chair, sorry, must I go first? Okay. Yeah. Look, firstly, in respect of the issue of the specific date of commission, there has also been developments on the chat. So I think ultimately there was a suggestion from the department that the matter be clarified or specifically set out in regulations, which I think we will obviously not have an objection to. And I think it has also been on the chat, even though I don't think the chats are supposed to form part of committee proceedings, clarified by the Helen Suzman Foundation that they, as a matter of fact, only refer to multiple crimes which are being dealt with by the NPA in one prosecution and not necessarily subsequent crimes. So in that sense, I think we understand one another. I think the Honourable Self would respond in respect of the Van Vuuren and Van Wyk judgments issue. Thank you, Chair.
Thank you. With respect to the charts, I think any ruling by the chair as to the status of the charts would be of no significance because people just read them, and I think they do enhance the quality of the discussions. Even when we were dealing, I think, with the GBV bills, the public hearings, I think there was a lot of interaction between ourselves and members of the public on those charts. So I think it's one of the issues maybe at some point the Rules Committee might want to deal with. But I think for now, until there is a specific rule that says that they should not be considered, I do think that they do enhance the quality of our debates, and some of the information that we received or we get from these chats does empower us as members of parliament to make informed decisions. So even Mr. Horn has made some of his input based on those charts. So whether I say that we should not, it will be neither here nor there. Mr. Sir?
Yes, thank you, Chairperson. I am partly covered by Mr. Van Wyck's response. I think a lot will depend on what comes out in the regulations as well. But I really wanted to deal with the question of regulations. I've been trying to find the requisite provision in the Correctional Services Act. But as I recollect, regulations promulgated by the minister or the department have to be approved by this committee, as I recollect. And I would very strongly support that retention of that provision in the new legislation for the reasons that I think you have alluded to, that this has the status of law. Those laws should be properly scrutinized, and I just can't lay my finger on exactly where that is in the Act, but I think it should definitely be retained. Thank you, Chair.
Thank you very much, Honorable Mfuke.
Thank you, Chair, and thanks for the briefing by Mr. Van Wyk. I think it actually confirms what we were saying about the parole board and many regimes. Chair, I just wanted to check on the question that I asked yesterday, if maybe before I came in they did answer, on how many of the matters are currently on how many offenders are currently incarcerated still. That falls under the category of the Van Wyk judgment. And I don't know if maybe they managed to can give the answer today.
They have, Honorable Mfuke, but I would ask that they share that information with the committee secretariat so that it can be circulated to members. They have explained it in detail, and there is a breakdown from the presentation that they have made. But I would ask that the presentation be circulated to all members so that we have the presentation.
Thank you.
Thank you very much. Do you want to come back, Honorable Sir?
Yes, thank you very much. I found the provision at section 134 sub 5 of the Act. It says the minister must refer proposed regulations to the relevant parliamentary committees in both houses dealing with the department. So I'm not sure whether that actually happens, but it really ought to happen, and ought to happen into the future.
Thank you very much. I think generally there has been no objection that we would want to see those regulations. We will insist that we see those regulations because that is the meat of the legislation. So it would, before they are operationalized, we will have to see them. Now, given the fact that all our concerns have been clarified, I have the ANC, I have the ACDP that supports the bill, and so the DA, after the clarification, I get the impression that you also do support the bill in its current formulation.
Chair, as always, we will reserve our position for our caucus to take an informed decision. And before the Honourable Jantjie come in, I could just advise him that I think he's lost some privileges in this committee due to forever being in the Magistrates Commission.
You draadsetter, you draadsetter.
Okay, no, thank you very much. Honorable Yako.
Yeah, Chair, as usual, you remember that I'm not the main member of, so I would probably have to consult with my colleagues just to see where we are. Otherwise, personally, I have a few concerns which I have pointed out to the committee, but I have no issue with the gist of the matter at hand. Thank you.
Thank you very much. I think when you go to the program, we will set a date for the adoption of the report and the adoption, the final adoption of the bill, so that the bill goes to the National Assembly. We are targeting the date of the 23rd of February for the bill to be debated in the National Assembly, and because we want the NCOP to have enough time to process the bill. Thank you very much, Department of Correctional Services, for the hard work that you've put into this process. Thank you very much. But it's something that is structural. If there is no dedicated team that deals with drafting, and it is dealt with in an ad hoc basis, it is extremely unfortunate. And we are talking about a 26 billion rand department. It is extremely unfortunate. What type of structure do you have that does not take into consideration something that is supposed to be a core function of a department? We are a nation under reconstruction and development. That means that quite a number of legislations from the apartheid era needed to be redrafted, overhauled, and you are dealing that on an ad hoc basis without the requisite capacity. It's unacceptable. It's totally unacceptable. I'm not sure what has been happening over these many years that you have overlooked to have such capacity. Thank you very much. When the minister comes after the State of the Nation address, we would want to ask on that. Why are we not having both the minister and the state capacity in the department whilst we have such a big budget? So thank you very much. Honorable Janja, I see your name. You want to speak on?
No, don't worry, Popes will dance.
Okay, thank you very much. Thank you.
Thanks, Chair.
Thank you very much. Honorable Ngola.
Thank you, Chair.
I think Chair, we must use the same tone we are using when we put them on the field.
We can't hear you. Can you repeat your Honorable Kola? Can you repeat what you are saying?
No, I was saying, Chair, the tone you have just employed on your closing remarks must be the backbone of the 5th of March meeting with the department.
Thank you very much. Thank you very much. So the department is excused to go and do other things. Thank you very much, Ms. William Lambondlovo, and to your team.
Thank you, Chair.
Thank you.
Thank you, Mr. Chair. Have a nice day.
Thank you very much. Mr. Van Veeren, it's a whale.
Jacques van Wyk.
We have 2 items left, members. We have the matter in fact, the issue of the program that was raised sharply by members. We have tried to rework the program to bring back the Fridays. So the program has been circulated to members. Let us discuss what is the feeling of the members on the revised program. Honorable Juan.
Yes, thank you, Chair. I think from my side, I want to say thank you that the input has been considered. I think the program as it stands now better reflects the issues this committee has previously identified as priority issues, and I think the program will enable us to fulfill our role properly as it stands now.
Thank you very much, Honorable Hon. Honorable Mufuke.
Thank you, Chairperson. I agree with Honorable Hon. The program is now in line with what we're requesting, and we support.
Thank you very much, Honorable Mufuke. Honorable Chele.
Chairperson, thank you for the good work that the team has done together with you, and we welcome the program.
Thank you very much.
Yes.
No, thank you very much, ma'am. Honorable Swart.
Chair, just briefly, we are grateful for the amendments and we support the program.
Thank you very much. Thank you very much, Honorable Swart. I think the program is a great tool. So this is what is going to be guiding us. Honorable Swart, as our senior counsel in the programming committee, part of the challenge that we have is that parliamentary program just changes overnight. And sometimes it does not take into consideration that other committees have serious issues and their programs are packed. So any changes to the program, even if it's for 1 or 2 days, it seriously puts those committees off. One of the issues that we would also be doing to try and accommodate this program is for certain days where there are no serious deliberations or there's no voting. There are always serious deliberations. So let me correct myself, my apologies. There are always serious deliberations in the House, but in certain instances where there are no voting or where our cluster is not answering questions or is not asking questions, we would ask some of the days so that we can sit to ensure that we finalize the program. I think for this term, in fact, is the most important for the whole year for this committee. It's important that the bills are passed. We have already dealt with this Correctional Services Amendment Bill, which is a constitutional imperative for us to conclude. And we have to deal with the issue of the South African Human Rights Commission, which is very important for us to conclude. So this is a very important term for this committee. So if we succeed in achieving all of these issues, I think we would have succeeded for the whole year. So, but one of the issues that I think we want to put as an issue that members should know is that the next term, when we come back, we'll be dealing with the budget, but we would be giving a lot of time to correctional services. Before the lockdown, we have asked no less than 2 weeks of time from correctional services from time to time to deal with justice matters. So we do owe correctional services a lot of time. So the first 2 weeks, which will be referred to as committee weeks before we start with the program, there would be, before we start with the budget processes, those 2 weeks would be given to correctional services. And then thereafter, we would want to propose a change of focus in how we deal with the program of both committees. This issue of just Fridays for correctional services would not give us enough time to do justice to correctional services. I think it's something also, even with the ministry, we have to have a discussion, because work seems to be coming from one angle, that is the justice side, and as a result, tilting our focus to focus from where work comes from. So it would be important that we don't just squeeze correctional services matters to be Friday matters. We must sit down and have a planning session for the term before the term starts and say what are the critical issues on both departments, how do we prioritize them. I think the current approach, it was good for the start, but quite clearly it would, by the end of the term, if we go the way we are going, we would not have even made a dent to the problems facing the Department of Correctional Services. It is generally astonishing that you can have a department as big as Correctional Services that does not have a drafting section. So it shows the extent of the challenges in that department. And I think if we overlook those, we would have created or caused serious injustice in terms of our oversight over this particular department. That is all I wanted to raise, Chair, honorable members, in as far as the program is concerned. Thank you very much for your kind words, and to the team that has worked very hard to ensure that we have a program that is acceptable to everybody. The next item is the letter of the minister. We know that we had that situation of the chairperson of the audit committee, and we asked that there should be an investigation by the minister, whether the chairperson said those words or whether those words were directed to the members of parliament serving on this committee. The chairperson, the minister wrote back to us. The letter has been circulated. He requests more time because he received the report on the 28th of January. He is still interacting with the report. So he has asked us to give him more time. So that letter has been circulated to all members. Can we now interact with the letter of the minister? I would note hands. Honorable Horn.
Yes, Chair. From our side, unfortunately, I don't think this is a healthy situation. Firstly, the amount of time given for this investigation to unfold and for this committee to receive a report on it was a sufficient amount of time. As our recollection is that as it is, the minister indicated that he would be undertaking the investigation himself. And it is therefore strange to now see that the National Commissioner has been tasked with the investigation, specifically given the fact that the circumstances indicated that he would be somebody who could personally shed light on what transpired on the day, due to the fact that the chair of the audit committee, in one of her versions of the event, indicated that she was actually speaking to him while she was speaking Sesotho. In addition to that, the minister says in his letter that he has now received the report, and then the question must be asked, why would he need 2 weeks to engage with the report if the report is supposed to be the report? He might have a view on the report which he can share with the committee, but obviously it's not a draft report he received. He gave somebody now the authority to undertake the investigation, and the report received by him is the report that this committee must now receive. So from our side, our view is that the report must come without further delay to the committee. And if the minister has a specific view on the outcome of the report, then he, of course, can share that with the committee as well. But it is not a proper process, and it with the greatest of respect, raises a few questions as to what then will be the ultimate outcome within 2 weeks if the minister wants to, as he puts it, engage with the report. So our view as chair that we as a committee must insist that the report be immediately filed with us, and that the minister be afforded an opportunity to give his views or his input as well, in addition to the report, if he so wishes. Thank you.
Thank you, Honorable Horn. Honorable Swart.
Chair, I tend to agree with the Honourable Horn that it is regrettable that extra time is now being asked, given the fact that we gave an extended period. I think when we initially discussed this, we wanted response by the end of December, if I remember correctly, or the middle of January, and then we gave it to the end of January, which is a lengthy period, and I do believe that we should get that report as quickly as possible. I remember the National Commissioner specifically saying he had no jurisdiction over the Audit Committee Chair. I appreciate possibly what the Minister is saying. He'd like to hear what the National Commissioner's involvement and what the conversation was about. So it's not necessarily the National Commissioner's report, but I do find it regrettable that the Minister is asking for more time, and we need to possibly be a lot more firm in that regard. Thank you.
Honorable Mfuke.
Thank you, Chairperson. I do understand our colleagues on this because we're waiting for the report, but we should also really look at the paragraph where the Minister is saying, I'm requesting the Portfolio Committee to grant the Executive Authority an extension. It's a request. And if it's a request, it's for us to say yes or no, but I'm also thinking that maybe he was supposed to have actually written a reason onto why, and otherwise it wouldn't be a problem. But I feel that we should grant him that actually permission to actually get 2 weeks and reply to us, because we don't even know what is happening here. But let us really take that request and grant him the permission. 2 weeks is not far. I do hear what the honorable members are saying, especially on what was said by the commissioner. And it was going to be also my question to say, why was the commissioner given that responsibility? Maybe the minister realized that and has decided to give the responsibility to somebody else. Let it be something that we know, or maybe it's not actually how he saw it coming. We don't even know the terms of references that were given on that for the commissioner to do the work. That's my understanding. And with that, I would request that we give him that permission.
Thank you very much, Honorable Janji.
I'm fine. I'm covered, Chair. I'm fine. Covered by Honorable J.K. Muffuke.
So, members, we have two views. One is that the minister we should not give him an extension. And the other one is that the reasons advanced by both Honorable Swart and Honorable Horn are understandable, but we should, because we don't know the reasons, we should, at least because it's the first kind of extension that the minister is requesting, that we should give him the extension, but with those strong caveats that Honorable Mofokeng has raised. And so we have two views. Can we deliberate on the two views? Honorable Swart?
So maybe we should just express our concerns in our letter. The Honorable Mafokeng indicated that no real reason is given for the extra time. I don't have a major problem with giving a bit of extra time on, but we could express in a letter the fact that we gave an extended period. It is regrettable that extra time has been requested, given that no reasons have been put forward for the extra time, but under the circumstances we are prepared to grant it. That would probably be my